what is the typical process or steps in a criminal case in Washington state? Are you interested in that subject? Are you dealing with a criminal case and you just don't know what to expect? Well, if those things apply to you, stay tuned because this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes for more than 20 years. And I'm putting out these videos as a way to educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. So we often make assumptions as defense attorneys that our clients just know what to expect, how a criminal case works. So I'm going to talk about in this video from the client's point of view, the defendant's point of view, what are the typical steps in a criminal case? Now remember, your case may be different. There's different steps for felonies than for misdemeanors, and most of the steps don't include stuff you might see on TV. But let's just talk about a standard charged non-felony case, a DUI, an assault, a theft, something in a municipal or district court in Washington state that's already been charged. So if you're charged with a crime, you've either been arrested or you received a complaint in the mail telling you to go to court. And that first court date is called an arraignment. An arraignment is where you enter a plea of not guilty and the court sets conditions of your release. What does that mean? Well, conditions of release means that the court's going to look at your prior criminal history and the facts of the case and decide, should you have to post bail to stay out of jail while the case is going on? Or can you be released on your own personal recognizance, or people call it PR, personal recognizance. You might hear own recognizance, just means without bail, basically. Additionally, the court can set conditions of your release. And typical conditions include don't commit any new crimes, keep the court notified of your address in case it changes, stay in contact with your attorney. Some courts will say get an attorney, which you pretty much need to do in a criminal matter. And there could be special conditions. Don't have any contact with the victim, right? And that's a big one. It could be your wife or husband or boyfriend or girlfriend. They could say don't consume any alcohol or non-prescribed drugs as a condition of staying out of jail while the case is going on. They can say make you put an ignition interlock on your car in some DUI cases, or make you wear a GPS bracelet in some cases. Bothell Court does that quite a bit. So there's different things that they can put down as a condition of release. And if you violate that condition of release and the court learns of it, they can put you back in. They can put you in jail, even if you were never there. Just put you in jail for violating conditions. So you need to pay attention to them. What they're also going to do at the arraignment is they're going to set you a court date for non-felonies. We typically call those court dates pre-trial hearings. So at the arraignment is not to discuss whether or not about what happened. It's not to plead your case. It's not like a traffic ticket where you go in for one hearing and say, Judge, I wasn't speeding. Here are the reasons why, right? It's a hearing to inform you of the maximum penalties, to set additional court dates, and set conditions of your release. And typically, you're always going to enter a not guilty plea in that type of hearing. So between the arraignment and the next court date, which is often called a pretrial, your attorney is going to most likely receive something called discovery from the prosecutor. Discovery is a term in the court rules. That's where it comes from. It's in the court rules that says that the defense is entitled to discovery from the prosecution. And that typically means all the evidence the prosecution has for you and against you, typically all against you, that they intend to use against you in your case. And that discovery typically includes police reports, photos, statements from victims, now more and more body camera video footage, it could, car video footage, 911 calls, things like that. And so the court rules say that within 3 weeks of your arraignment, your attorney is entitled to discovery. And if the prosecutor is late in getting discovery, except in sending discovery, Usually the remedy is a continuance. Occasionally, in really, really egregious cases, other things could be brought up by your attorney, but we're talking, leave it to them to figure that out. But you don't win if they're late with the discovery typically. It just means that it's easy to get more time. So once your attorney gets the discovery, typically, most attorneys are going to review the discovery on their own. They're going to take a look at it. They're going to see, does it look complete? What do they think about it? Things like that. And then, for example, in our firm, we're going to get a hold of our clients and set an appointment for them, either to come into the office to look at the discovery or to do it over Zoom. We're filming this during 2022, COVID times, or even over the phone. Typically, the defense is not allowed to send the defendant a copy of the discovery. There are some exceptions, and there's things that can be done to make that happen in the court rules that are fairly onerous. And I think the reason why the court rules is like that is if defendants have the discovery themselves, perhaps they're worried about, witness intimidation and things like that. I don't really agree with that, but so if you ask for a copy of the discovery and your attorney says they can't send it to you, it doesn't mean they don't want to. It just means that's what the court rules say, that the discovery has to be maintained in the possession of your attorney. So once you've gone over the discovery, typically the next steps may be the attorney assigning you some stuff to do. Maybe they want you to do some classes, or maybe they want you to get them some witness information. Maybe they want you to watch the mail for a notice from a department store if it's a theft case. There's lots of different things. And then you'll eventually end up going to a pretrial hearing. And a pretrial hearing is a lot like what it sounds like. It's a hearing prior to a trial. And it doesn't mean there's ever going to be a trial, but what I explain to our clients is that think about a pretrial hearing as a way to force the parties, the prosecution and the defense, to acknowledge that a case exists and to move the case either towards a resolution or towards legal motions or towards a trial. When I say resolution, it means an outcome, a dismissal, a reduction, all types of stuff. And the most common outcome of a pretrial hearing is another pretrial hearing. Do you participate in the pretrial hearings? So for the most part, you are required to show up, listen to your attorney. There are some waivers nowadays during COVID that could be signed, but typically if you fail to appear for a pretrial in Washington State, you'll get a warrant issued for your arrest. But you participate in the pretrial by being in the building or on the Zoom call, but you're really not part of the conversation besides perhaps answering to the judge that you understand what's going on and talking about speedy trial waivers and things like that. So between the first pretrial and the second pretrial, there might be more stuff that happens, right? Maybe there's more stuff you need to do. Maybe there's stuff that the defense attorney does. Maybe the defense is talking to your witnesses. Maybe the defense is talking to state witnesses. But typically there's multiple pretrial hearings that work the exactly same way, exactly each time, and until it gets towards a resolution. Now at the pretrial hearing, will it just be you in court? No, it's you and maybe 40 or 50 other cases on the same calendar. So you're not going to get singled out typically. Once the attorney thinks it's time to negotiate your case, if it's a case they want to negotiate, they'll typically reach out to the prosecutor prior to some pretrial hearing, usually closer to it than not because the prosecutor's pretty busy and you want to talk to them at a time they want to be talked to, right? Typically your attorney will reach out to that prosecutor and maybe there'll be an offer made. And that might be an offer that you need to discuss with your attorney to decide if you want to accept or reject. So if there's no offers made or it's a case you don't want to settle and there's some legal problems, your attorney might set the case for motions. That would be one of the few times you might see the law enforcement or witnesses involved in court. You're not going to typically see them during the pretrial hearing. A motion hearing, to suppress evidence, like an illegal breath test or something, would require the police officer to come in and then swear under oath and testify like you see on TV, that type of stuff. If the case is a resolution, then oftentimes the case will be resolved at a pretrial calendar. And that often involves paperwork, plea forms, SOC form, stipulated order of continuance, or the state or city could be moving to dismiss. And finally, in a rare instance, your case might get all the way to a trial. And a trial typically would be by jury. And that would again be like what you see on TV, where jurors come in and they get questioned and they get selected and impaneled, and then all the evidence gets heard. The state calls their witnesses. Your attorney gets to cross-examine them. The defense calls your witnesses. You have a chance to testify, talk to your attorney about that, and then a jury decides whether or not the prosecution has proven their case beyond a reasonable doubt. But most likely your case will be resolved at some point between the arraignment and so many numbers of pretrial hearings. At a resolution, at a misdemeanor case, if it's a plea and sentencing, that'll typically happen in the same day. In felony cases, if there's a plea and sentencing, they're often on separate days. So if you have a resolution and you're going to wonder, do you need to talk about the case? The defendant has a right to make a statement when they're sentenced, if this is a case involving sentencing, but you're going to want to talk to your attorney about what you might want to say and things that you could say that might help your situation versus things you could say that could hurt the situation. So, a criminal case is pretty unexciting for the court part for the defendant if they know what to expect. It's a lot of showing up, it's a lot of listening, and it's a lot of paying attention to what's going on. It's not a lot. You're hopefully not going to ever get questioned by the prosecutor. You're not going to get questioned by the judge. Your attorney is not going to let that happen. Things would only happen if you testify or if you have some type of resolution where you're asked to give a statement. So I hope this clears it up some about how the criminal process works from the defendant's point of view, sort of the steps in most cases, and other firms may do it differently, but most of the firms that I know do it this type of way. So if you find yourself in this type of situation and you need an attorney, feel free to give my office a call. We've been doing this for more than 20 years. If it makes sense, we'll set you an appointment. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.